friends, Casey Ashmore coming to you from the studio. So we got this new informal, less formal. I don't know how I feel about it. It's kind of weird, but dealing with it, making the best of it, being great, trying to get you guys some great content, some great information. And what we're talking about today is the best interest standards in these temporary orders hearings when a parent is facing a custody dispute, and we're trying to get as much information packed into this video series so you have an idea of what is custody, what is a custody battle, what does that mean. So we're talking about the best interest factors, and just recap: temporary orders, you got two good people, no pattern in history of family violence, you got two good people. They're competing for the right to designate the primary residence. It's really what it comes down to. You get that right, you have the right to receive child support in almost every case. So those are the things that are the competing interests. You got two really good people. How do you move the needle on that? Well, we talked previously about other factors: child's desire, history of violence, no history of violence, history of emotional instability, no history of emotional instability, where that moves the needle in this. To this video segment, we're talking about things that are other factors, which is the parenting abilities, right? And it's like, who did all the times tables, who was doing all the homework, who was making the peanut butter sandwiches, who was getting them on the bus, off the bus, to the doctor, from the doctor. All of these things, the parenting abilities, are definitely a factor. You got one high earner and one person taking a diminished job or a homemaker role. Those are going to move that needle, right? Because it's going to show a pattern of, who's the caregiver day in, day out, day in, day out. Who's the caregiver? Who's getting, high earners, don't be afraid of the fact that you're a high earner or you're a hard worker. That shows that you're a provider. That doesn't show that automatically you should be the one slapped with child support just because you're the high earner, or that there was an agreement in the marriage to do things that way to facilitate time with the kids. Adjust your work schedule. Do whatever it takes to, make yourself a competitor in that situation, so that, there's not a deal where, you've left your right to request this relief on the table or backed off of it, because there's nothing wrong with being a provider. There's nothing wrong with being a high earner. And that is, in fact, one of the factors, right? It's the resources available, right? Like, what can one parent provide over the other? More stable home, more opportunities, this, that, and the other. Just because that person is a high earner. And again, on the flip side of that, if you've taken a diminished role, just because you've taken a diminished role doesn't mean that automatically means your children are going to be clawed away from you and you're going to be paying child support. Other parents are going to be the primary because you were a homemaker or you took a diminished job. It just means that you're going to have to level up. You're going to have to think. But again, don't walk away from that opportunity to ask the court for that relief if an agreement can't be reached, because it's going to be, yes, work schedules are a factor. Work and travel schedules are a factor, but they're just a factor, right? As to which parent can give the children the most and who's got, the opportunity and ability to give them their best parenting abilities, right? And of course, a big factor in that is going to be, parental interaction with the children in the past, the child or children in the past. And, it has a strong impact on the custody decision. So, even in situations where the high earner is, working hard, working long hours, this, that, and the other, doesn't mean that they weren't there. Doesn't mean that they didn't do their portion. Might have handled the mornings. The other parent handles the evenings. So that way both parents can work and fulfill their financial and provide for their families. That doesn't mean that it's going to be a strike against you. So those are simply factors. Other factors are, what programs, ties to the community, familial support, what schools and what have you, what's going on in the scope of that child's universe that's available to them in each household. Those are definitely factors the court's going to consider. And then, of course, what the parents' plans are individually. Like, this is the plan for my child. If we move into this, or we stay in this school district, we stay in this community, we stay in this household, or vice versa. Look, there's an opportunity right over here, closer to, still within the geographic restrictions of the court, but closer to more family support. Bing, bang, boom. There's other factors. All those things go into that best interest balance. And what's mind-boggling to think about is that all of this happens in about 40 minutes to 1 hour. It's a really compressed timeline. The courts have to take time out of the equation and really drill this down, because on this initial determination, it's a judge decision, like I said in the prior video series. So the judges do have to make these determinations quick, and they have to do it. It's a hard decision. They have to do it quick, and they have to take these two essential strangers at the word, and then give weight to who has the greater weight of believable evidence. Now, there's more factors here. Going to get into those in the next video series, but these are just some of what is packed into that best interest standard that we talked about a few video series ago. So hopefully this will help clarify some more, educate some more. That's the whole purpose of these video series, to reduce anxiety for those facing custody issues. And please like, subscribe, and share. And also leave me a question or comment on any video platform you see this on. I'll get back to you, direct video message, both, or email me at chat, CHAT, at ashmorelawfirm.com, chat at ashmorelawfirm.com. Thank you.